Hello, my friend and family who are joining us today on Zoom, and supposedly we will go Facebook Live as well. I hope everyone continue to stay home and be safe from COVID-19. We are in this together and we will overcome the crisis. My name is Ken Fan. Today I will co-host with my business partner Yui Lei for our session. A little bit about myself. I work as a financial consultant for about 10 years. About 2 years ago, I was introduced to an incredible opportunity to pursue my passion and my dream. I'm an advocate for financial education and financial planning, and an entrepreneur with the deepest desire to help to bring more value to the community and humanity. In the past almost 2.5 years, I have witnessed and experienced my own transformation in personal growth and as well as financial knowledge. My co-host today is Mr. Yui Lei. He's a father of 4 beautiful children and a wonderful husband to his caring and loving wife, Faith Lee. Before starting WFG business almost 7 years ago, he was a chiropractor with a mission to alleviate pain for people in need. Now he is building financial business across the United States and Canada to help to protect families from financial risk and improve people's financial health. Together, we fight for financial literacy and financial independence for middle working class family in North America. This is our third Facebook Live session live today. We will be sharing with you valuable tips and advice for our community during this troubling time. We have invited this amazing, beautiful, talented, intellectual attorney, Elizabeth Yang. I got a chance to know Elizabeth about 2 years ago. What I can describe of her is what she's very hardworking, resilient, and admirable individual. Not only she graduated honor from UC Berkeley as an engineer, super smart, but she continued to pursue her passion in law and specialized in business and family law. She saw that it was a great opportunity to serve and make an impact in the community. Through many years of hard work, dedication, and sacrifices, she is now very well recognized in our community across Southern California. She was awarded as a top 40 lawyers under 40, and now is ranked among the top 2.5 of all lawyers in California and the top 10% across the nation. It is our absolute honor to have Elizabeth with us tonight. We believe in financial literacy and the importance of proper estate planning in our wealth preservation. And please, for all the audience, if you're joining us either on Facebook Live or on Zoom, Elizabeth will have her presentation. And then if you have any question, you can start typing the question in the chat room. And at the end, we will have a Q&A session open up to answer any question that you might have. And let's just get going. Thank you, Elizabeth, for being here with us tonight. I'm sure the community will learn a lot from you. All right?
Thank you so much for having me, Con, and for setting up this webinar so that we can educate our audience. It's my pleasure to be here. Do you want me to just jump into my presentation, or you want to ask some questions?
Just go ahead and start with the presentation first, and then we will open up for some questions.
Okay, great. So it looks like we have a full house already. More than 60 people so far, and more people still jumping on. So today our topic is the importance of having a trust during this crisis period. All right, so I know a lot of you have heard of the word trust and also heard of wills and estate planning. And I'm sure many of you have not gotten around to getting one drafted and signed yet. So here's already. More than 60 people so far, and more people still.
Sorry.
I'm hearing my echo. Yeah, so it's the perfect time right now while we're all sitting at home. Instead of just watching Netflix all day long, why not get your will and your trust created so that if anything happens, because the times are so unpredictable right now, your assets are protected. All right, so I'm going to share my screen with you all. That way you can see my presentation, and I'm going to go into details about what exactly is a trust. And with that, I would also have to explain what is a will, because wills and trusts go together in the estate planning world. And I'll also share with you guys what a power of attorney is as well. So we'll go over all of these different aspects so you can learn the lingo, and then you can decide for yourself which one is the best thing to create during this time. Okay, so if everyone can see my screen, can you all see the PowerPoint? Okay, great. So we'll start off with, here, let me see. Okay, so we'll start off with wills. On the screen in front of you, this is the official definition for a will. So a will is a declaration of how a person wants his or her property distributed after death. So the main thing about this is that a will does not come into effect until after the person passes away. That is different from a trust, which we'll also get more into, which happens immediately when the trust is created. All right, so a will, these are all the benefits about a will. You can specify how your property is distributed when you pass away. And properties include real property, it includes personal property, bank accounts can be specified, houses, apartments, CDs, stocks, basically anything that you can put a title on can be specified in a will. A will also helps you reduce taxes, same as a trust, and we'll get into that as well. You can also name fiduciaries. The executor, there's going to be a lot of terms. So the executor is the person who has created the will. So it allows the executor to designate individuals as guardians for children. It waives security on bonds, and it could provide for disabled family members. So here are all the different terms. We went through the will. The executor and the testator is the same name as the person who makes the will. The beneficiary is the person or people who get the benefit of the will when the testator dies. And here are the requirements for making a will. Number one, it has to be written. So if someone verbally promises you property after they pass away, guess what? That's not going to be enforceable when the time comes. So it's got to have, it has to be in writing, it has to be signed by the testator, and it also has to be signed in the presence of witnesses. In California, the requirement for the number of witnesses is at least 2 witnesses. Testamentary capacity means that the person has to be in the right mind to prepare and sign the will. If the person is already on his or her deathbed and cannot think clearly, then it's going to be very easy for the will to be set aside later on and deemed unenforceable by a judge. So you want to do it now when you're healthy. Don't wait until you're already, not capable of signing anymore, because then the will, even if you sign it, is not going to really help your beneficiaries. What does intestate succession means? It means when you don't have a will. So for those of you who don't have a will today, if something happens to you and you don't have your properties specified as to how it's going to be distributed, you would be dying intestate. And what it means here, as shown, is that in California, if you die intestate, the order is the property first would go to your spouse. If you're not married or if you don't have a spouse, it would go to your children. If you don't have any children, it will then go to your parents. If your parents have already been deceased, then it will go to your siblings. If you don't have any siblings, then it will go to your grandparents. And if you don't have any of this family, then it goes to the state. And the thing is, if you don't have a will, you have to go through what's called probate. So even if your spouse wants to get the property, if it's not already in your spouse's name, they still have to go through probate and go through court, spend a lot of money, spend a lot of time in order to access any of your property under your name. Same with your children, parents, siblings, and grandparents. So if you want to save them time and money, get a simple will drafted today. It doesn't touch any of the property today, nothing changes. It only gets executed when the testator passes away. So now that you know the basics of a will, let's jump into the meat of the presentation, which is trust. So trusts are very important during today's crisis, mainly because there's a lot of advantages that trusts have that wills don't have. So here is the official definition. A trust is a fiduciary relationship with respect to property in which the trustee holds property for the benefit of another person, the beneficiary. All right, so a lot of terms, and instead of just being a document like a will is, this actually creates a relationship. So here are some of the terms. All right, so earlier we had the executor and the testator who created the will, while the settlor or the trustor is the name of the person who creates the trust. The trustee is another person that gets to hold legal title to the trust and gets to manage the trust. So if you're married, for example, and you want to create a trust for your separate property, you can name your husband or your wife as your trustee. So if something happens to you, your trustee would manage how your assets are distributed to your beneficiaries. And beneficiary, of course, again, is the people who get the values and the benefit of the trust that's created. Same meaning as from a will. And we can entertain any questions at the end of the presentation. So write down your questions if you have any, because I know we're going through a lot of information in a very short period of time. All right, so here is a chart that helps you understand the entire relationship. In the green square on the top left corner, that's the settlor. That's the person who creates the trust. So if you create a trust today, your name would go there as the settlor's name. You are giving legal title to the trust corpus to your trustee. So the trustee, again, could be your spouse, it could be a sister, a brother, a mother, a father. Anyone who is 18 and over can be your trustee, who you trust to manage your assets. And they're managing the trust for the benefit of the beneficiaries. So anyone can be the beneficiary. It could be your children, it can be your spouse, it can be your parents, it can be friends, non-relatives. Anyone can be named as beneficiaries. What are the advantages of a trust now? Same with a will, you avoid probate, the very expensive and time-consuming process, so that your beneficiaries don't have to go through that probate process. For guardianship proceedings, you can avoid that as well, because you can just set a guardian in the trust and it comes into effect immediately. Privacy, that's one big thing that trusts have that wills do not. So if you have a lot of property under your name and you don't want people to know about it because people come after deep pockets, if they know that you have a lot of property, they're probably going to want to come and sue you. So you don't want all that property under your name, because anyone can just go up and search your name, for example, and look at all the real estate that you're entitled to. So if you create a trust, you can put all your real estate, all your assets into the trust. And when people search your name, they're not going to find anything. Well, there's a lot of attorneys out there that when they create a trust, they call the trust that person's name. So for example, it would be like the Elizabeth Yang Trust. Well, that doesn't really give you much privacy, right? Because if they see a real estate and it says Elizabeth Yang Trust, they're probably going to link that to me. So instead of using your name in the title of your trust, use a different name. A lot of Chinese people, for example, like to use something auspicious like the Lucky 888 Trust, or the Fortune Money Trust, something like that, that doesn't associate with your name at all. So people won't know that that real estate belongs to you. Okay, so that's one really important aspect for trust. It gives rich people privacy. There's no public record of it, and no one will know how many assets you own. It's also easier to manage when the trustor is incapacitated, because you already have a trustee who you've designated to manage all your assets. And last but not least, just like a will, there's tax savings. And that's what everybody's probably interested in. So let's go into some details about tax savings. Well, first of all, what are the different types of taxes when someone passes away? Number one, there's the federal estate tax. That is 40%, which means all of your assets, if you have to pay federal estate tax on it, 40% of that goes to the federal government. That's a lot of money. There's also state estate tax. Good thing in California, there's no state estate tax. But if you own property in other states or you're currently residing in another state, there's currently 12 states that do have state estate taxes. There's also inheritance tax. Fortunately for us Californians, we don't have inheritance tax, but these are the 6 states that do have inheritance tax. So how does a trust help you with the federal estate tax? Well, have you guys all heard of the estate tax exemption? This estate tax exemption changes year to year. So currently in 2020, it's $11.58 million per person. That means that each person can give away $11.58 million in his or her entire lifetime without having to pay any federal taxes on there. Any dollar over $11.58 million will be taxed at the 40% federal tax rate. Okay, so you want to be able to, so this is, mainly for people who have more than $11.58 million to give away in their lifetime. If they don't, then it's not a big deal. But if it is, if they do have more, they don't want to give all that money to the federal government. So they want to make sure that it all goes into the trust and it's protected when it goes to their beneficiaries, so it does not get taxed at the 40% level. And if you see these different years, in 2016, it was $5.45 million. In 2017, it was $5.49 million. And then it jumped. It basically doubled in 2018. And that's because of the Trump administration. Trump, he comes from money and he probably wants to help more of the rich people. So he increased the estate tax exemption. So at this point, if you create a trust and you put in $11.58 million or however much money you have into it, that number gets locked in. So if 2021 or 2022 comes and we have another president, who decides to decrease this number back down to $5 million or whatever number, you're still grandfathered in at the $11.58 million because you already transferred your money during the year when it's at this high tax exemption. So we don't know what the future is going to be. We don't know if it's going to be higher or lower, but at least if you have more than $11.58 million at this time, you want to, pass on that money in a trust immediately. You don't want to wait until you die, because when you die, what if it's lowered? Then you wouldn't get this advantage and you would be paying 40% federal taxes. Plus state taxes if you live outside of California, one of those 12 states. So that's the importance of tax savings. That's why if you put your money into a trust now, you can get the savings immediately. All right, so we'll entertain more questions because I know I'm short on time. For trust types now, there's a lot of different types of trust. Okay, there's revocable trusts and irrevocable trusts. There's living trust and testamentary trust. There's funded versus unfunded. And we'll go through each of these ones so you know all the difference. The trust can get very complicated, but I'll try to simplify it as much as I can for you. So revocable trust means that the settlor, who's the person who created the trust, they retain the right to alter, amend, or revoke the trust. And an irrevocable trust means the settlor cannot revoke it, cannot make any more changes. The analogy that I like to use is if you take an Amazon box and you pack it in with your assets and you put it in and you just set it aside. Later on, you can always go back to that box and you can add more things in. You can take things out. The Amazon box, before it's sealed and sent out, is like a revocable trust. You can put more assets in. You can take assets out. You can change it at any time. An irrevocable trust, on the other hand, is you take that Amazon box, you put your stuff in, you tape it up, you mail it at the post office to whoever your trustee is, whoever you trust. Say it's like your brother in New York. You mail it to your brother in New York and your brother hangs on to it. He can never send it back to you. You can never get it back from him, and you can never add more stuff into that box. Okay, so that's an irrevocable trust. So why do people want to do an irrevocable trust versus a revocable trust? Well, most people, they do revocable trust because you can make changes. It's easy to revoke it. You can easily cancel it, amend it, alter it. Very easy. So most people want that. But there are some people, they create trust because maybe they're in a lawsuit and they don't want, the person who's suing them to get all of their real estate and their assets if they lose the case. So irrevocable trust is the only trust that will protect you in the case of a lawsuit. If anyone sues you and your money and your assets are in an irrevocable trust, then they can no longer touch it. It's sort of like that has already been transferred to a third party and you can't take it back. So it doesn't belong to you anymore. So you can't use it to pay any damages you owe. Revocable trust, on the other hand, does not protect you when a lawsuit is filed against you. So if you have a revocable trust, that's only for tax savings and all those other benefits that we discussed earlier. It's not for protection for litigation and for damages. All right, a trust is irrevocable unless the settlor reserves a right to revoke it. So there is a way to terminate and revoke an irrevocable trust. Number one, the trust has to contain that specific termination date when you draft it. So, for example, when you send the Amazon box to your brother in New York, if you put inside a note that says, hey, brother, on, January 1st, 2025, I want you to terminate this trust and mail the box back to me. Then that irrevocable trust can be revoked and terminated. But you have to have that note within that box when you mail it, which means you have to have that termination date in the trust written down before you sign and notarize it. If you don't have the note in there, later on, you can't send another note. You can't amend your trust to add it. When you send it, it's done, it's sent, no more changes. All right? So that's the only way to revoke an irrevocable trust. Otherwise, you can't touch it. You can't make any changes after it's been signed and notarized. The trustee then takes care of everything that happens based on the terminology and the specifics you put into that trust. All right, what is a funded versus unfunded trust? A funded trust is when you create the trust, you have property in there already. So say right now you own a house. You can create a trust, name it whatever you want, and then you can put the house into the trust. What that means is that you change the title. Instead of having your name on the deed, now the trust name is on the deed. For example, if you have a Lucky 888 trust, that's the name of your trust. Now on the title of your house is going to say Lucky 888 Trust. Is no longer going to say your name. So that would be funded. Well, what if you don't have a house right now, or you don't have any assets you want to put in there? Well, then when you set up a trust, it's called an unfunded trust. It's a trust that's set up without any property in it. And people set this up because they want to have a trust ready so that when they do purchase assets, they can put that in there. Or another good way to use an unfunded trust is if you have a will, you can do a pour over from the will into the trust. What that means is if you don't want the trust to be created now and you don't want to move any property into a trust, you just want to have a will and make sure that, if something happens to you later on, all your assets are going to go to the beneficiaries that you specify. But say you have minor children, for example. If you own a house, do you want your entire house to go to your five-year-old in case something happens? Of course not. Your 5-year-old's not going to know what to do with it. And probably someone's going to try to take advantage. So, you can't, what if, you don't trust your sibling or your mother to give that house to your son or daughter later on? Well, if you do a will and you say, I want the house to go to my grandma, to go to my mother, and then to go to my son, that's not going to work. Once it goes to your mother or your sibling or whoever, that's theirs. If they don't want to give it to your children that are minor children, there's nothing that's going to force them to, because the title is already going to go to your immediate beneficiary. So that's where you want to set up a trust, because the trust, your beneficiaries will be named as your children, and then you set up the adult, the person who's over 18, to be the trustee, and they manage the property. So they have a fiduciary duty to follow the terms of the trust and manage the property for your minor children. And you can put terms in the trust that says, when my son or daughter turns 18 or goes to college, or gets married, then this house or this asset will be transferred into that person's name. So you can set any condition you want. A lot of parents that want their kids to get married, for example, the term that they'll set a lot is, I want my kids to get married, and I want them to have children before they can get the assets. So basically any condition you can set, but that's the big advantage of a trust over a will. A will, there's no trustee. The will, the property just goes to your beneficiary immediately. The trust is where you can have a trustee manage the property for your minor children. That's the only way your minor children can grow up and get the property. And also, if you want the money to slowly go to your children, like, you want them to get like $10,000 a month until they turn 18. And then once they turn 18, they can get so much money every year instead of getting an entire house all of a sudden. You can specify those terms within the trust too. You can specify the exact amounts of how much will go to the beneficiary. It does not have to go all at once. Whereas in a will, when you pass away, all the property gets transferred upon death. Okay, so unfunded, again, is when you have a will, you can have the will pour over into the trust that's already created. The trust, for the meantime, just sits there without any assets in there. So a lot of people want to do that because maybe they're like, oh, we don't have that much property, so we don't need the privacy. So we don't need a trust right now, but we'll need it in the future. So we'll create an empty trust, and then we'll have a will, and then the will pours over into the trust. Okay, so that's a very popular way of doing it. So here's our slide. We'll go over powers of attorney. Powers of attorney also in this time of crisis is very important. Just like wills and trust, powers of attorney is not specified in terms of assets, but it's specifying a person to make decisions for you in case something happens to you. So you designate a person, an agent who acts like your attorney. They're like an attorney in fact, even though they're not a licensed attorney. So in case you are disabled, you're incapacitated, you're sick, and you cannot make decisions, you're at least the person who you've designated as your power of attorney can make those decisions for you. I had a client where she's like, well, if I'm ever on my deathbed and we need to decide whether or not to pull the plug, I'm going to leave the decision to my professional doctor because they've gone to med school. They know the best decision. Well, guess what? The doctors are not going to make that decision for you. That's why you need a power of attorney or this advanced medical directive that tells the doctor what to do in case something happens like that. Doctors are not there to make those decisions for you. You need to have someone you trust in your family or something written down for the doctor to follow so that they know what to do when the time comes. Okay, so advanced medical directives, otherwise known as medical powers of attorney, it specifies your desires during a terminal illness where death is imminent. So you don't have to make that choice later on. You can make it now when you're healthy. It allows the principal to designate an agent to make healthcare decisions if incapacitated or disabled. That way you don't have, a mom and a spouse fighting over the decisions. You already made the decision, and it takes a lot of the burden off of your family members. And then it also indicates procedures that where the principal authorizes the agents to withhold and withdraw. So I'm going to save a lot of time for questions and answers so we can go into more detail. That way I can see where people are understanding and where they are confused about. So let me go into the question. We have 15 questions so far.
All right, Tony, Elizabeth, let me cut in a little bit and kind of say hello to the Facebook Live audience. At the peak, we have about 69 people who are watching on Facebook right now, and there's a lot of questions coming in on Facebook. So I will ask some of the questions on Facebook, and then maybe you can answer some of the questions on the Q&A session, Q&A button, along with Khan also. How's that sound? That's good?
Yeah, that sounds great. I see the questions in front of me already. There's 17 questions so far.
Yeah. So maybe we there's some questions I read over, and I think you covered in the presentation already, but we can certainly entertain some of the questions on here. So if you want to kind of read over, Attorney Elizabeth, to see what you want to answer, and then I will ask some questions on Facebook as well. Okay.
Yeah, absolutely. So the first question here says, does it have any requirement for being a witness? So in order to be a witness, the person has to be 18 and over, and the witness also has to have capacity, meaning that the witness cannot be disabled or incapacitated himself or herself, just like the testator and the person executing the legal document. They also have to be healthy and be able to understand what they're attesting to. Okay, so that's the requirement for being a witness. And again, in California, the requirement is having 2 witnesses. And the attorney who drafts the will or the trust can be one of the witnesses. Another question here is, what is the order of nieces and nephews in the line of intestate? Unfortunately, if you saw my chart earlier, nephews and nieces are not included. So if you don't have a will and you go intestate and you don't have parents or grandparents or siblings or spouses or children, your nieces and nephews are not going to get any part of your assets. That's why it's really important to have a will or trust drafted. Even if you have surviving nieces and nephews, the state is going to get your assets before they are. So it's going to go to the state. And here's another question. For clarification, is Elizabeth saying that the will protects the property from probate? Yes. You don't have to have a trust if you have a will. Both the will and or the trust protects from probate. So either one will protect you from probate. If you have both, that's great. But if you have one of them and it's clear where your assets are distributed to, then you won't go to probate. What are the pros and cons of getting a will over a trust? So we went through the differences, right? There's a lot of differences. The big difference, just remember this, is that a will takes into effect when you pass away. Nothing happens now. You just sign a paper and you put it away somewhere safe, like in your safety deposit box, somewhere where when you pass away, then it gets executed. Nothing happens now. No title gets changed. Nothing changes at this time. Whereas a trust, things happen now. You change the title to your house if you want to put the house into your trust. You change the title to your trust name. A lot of things can start happening now. And then another big benefit is managing property for minors. The will doesn't allow for a minor to get property month to month. All the assets get distributed immediately upon death. A trust, you can manage it with the help of a trustee. Okay, so lots of different pros and cons. Let's see, next one. Does life insurance need to be in a trust? Good question. So life insurance usually has beneficiaries named already, so it doesn't need to be named. It does not need to be put into a trust. But again, if your beneficiary is a minor child and you don't want all that money to go to your minor child all of a sudden, then you should put it into a trust to have the money go to the minor children month to month or year by year. Okay, for state and inheritance tax, what if you moved to different states while living, which state and inheritance tax would you follow? Well, if you have a will and a trust, usually it will say the state that your asset will fall into. So, for example, if you currently live in California and your will or trust say we're going to abide by the laws of California, even if you move, it's still going to abide by the California laws because that's what your will and trust say. If you don't have a will and trust, then it's going to be based on where the property is located. So if you have one house in California, that's going to be based on California state tax and inheritance tax laws. If you have a house in Florida, that's going to be based on Florida state and inheritance tax laws. So all your properties is going to be handled by all these different states, and it's going to be a huge mess for your beneficiaries. So that's another big benefit of having estate planning done sooner than later. Okay, so next question. So the grandfather rule applies when the trust is established, not at the time of death. That's correct. And it's not when the trust is established, because right now, if you go and open up an unfunded trust and you don't, move any money into it, then you're not going to meet the $11.58 million. So it's really about how much money you're giving away, transferring to your beneficiaries. If you move $11.58 million into a trust for your beneficiaries this year, then you get that tax exemption this year. And they're not going to look at the tax exemption at the time of death. Right, so I hope that answers that question. Can we get a copy of the PowerPoint presentation? Yeah, absolutely. I'll be happy to send it to you. My contact information is currently on the screen. Just send me an email and I'll be happy to send over a copy of the presentation. And I also have an estate planning questionnaire that has all the information of stuff that you would want to gather and fill out to get the process started. So if you want that questionnaire as well, email me and I can send it to you too. All right, next question. With the reservation language, how is it different from a revocable trust? I'm not sure what the reservation language is referring to. So if that attendee is anonymous attendee, if you can clarify what you mean by reservation language, that'd be great. Next question, if revoked, will there still be protection against lawsuit? No, revocable trusts, like discussed earlier, do not protect against lawsuits. Only irrevocable trusts do. And the timing, they look at when the lawsuit is filed. So for example, I had a client who hit somebody and permanently injured the pedestrian, and the pedestrian ended up suing them. So they already knew that they were going to get sued even before the lawsuit was filed. So they came and they were able to create a trust very quickly, an irrevocable one, to protect their property in case the lawsuit proceeded. If you wait until after the lawsuit is already filed or too close to the filing of the lawsuit, then unfortunately the courts can still come back and set aside your trust and say that all your assets are still going to be liable for damages in case you're found to be guilty in the case. All right, other questions. What if we want to give the property to our children, but it's not paid off by the time we pass away? How will the children pay for the mortgage? So when you put the title of the house into the trust, there's going to be equity in the house. All right. So when the property goes to your children, hopefully, like say they're adult children, for example, the children will get the house and they can do what they want with it. They can rent it out and use the income from the rent to pay for the mortgage. They can live in it and pay for the mortgage, or they can sell it and take the equity in the house as savings and use that money. So basically, they'll be able to choose what they want to do with it. But you're not going to give, a house. If you give a house that's already underwater and there's no equity in it, then, the child who gets it, they can just foreclose on it and they're not going to get anything. But they're not going to be responsible for any negative debt, if the house is underwater when you transfer it. All right, next question. Unfunded type of trust, is that still called a living trust despite no trust assets? Yeah, it is. Living trust is a very popular term. Basically, it describes any trust that's created when you're still living at this time. So even if it's unfunded, if you create it now, it's still considered a living trust. All right, next question. What type of assets should go into a trust and what should be excluded? So any assets can go into a trust. Real estate, stocks, vehicles, bank accounts, checking accounts, 401ks, life insurance policies, all of that can go into a trust. If there's anything that you want to have managed right now, you should put that into a trust. Things that should be excluded for a trust. If you are flipping houses, for example, and you buy a house and you know you're going to sell it in a few months after you renovate it, don't bother putting that into a trust because you're going to be selling it anyways. Why go through the time and the complexity of putting into a trust and taking it out and selling it? So you don't need to put any short-term assets into a trust. Long-term assets should go into a trust. Next question, what are the responsibilities, limitations, or authority of a trustee? So trustees have a lot of fiduciary duties. They basically have to carry out the terms that are stated in the trust. So usually when you designate a trustee in a trust, there's a primary trustee and then there's also a secondary trustee. So if the primary trustee is not able or willing to carry out the responsibilities that's required of him or her in the trust, then the secondary trustee will take over. So when you create a trust, don't just name someone as the trustee without letting them know. And then all of a sudden later on, they get some letter saying, oh, you're named the trustee of this trust. And now you have to do all these responsibilities. And they're shocked. You talk to your trustee first. Let them know what you're doing and let them know that you're naming them as a trustee so that they expect to be carrying out these responsibilities when the time comes. Don't surprise someone with the responsibility of a trustee. All right, but do have a secondary one in case something happens to the first one. Can a trustee be changed in the irrevocable trust? No, the trustee cannot be changed. Basically, all the terms, once it's drafted, you can't change it anymore. So when you mail that box to your brother in New York, as we discussed earlier, you can't change it and say, oh, never mind, send that to my sister in Florida. It's stuck with your brother in New York. They're the one taking care of it. All right, next question. Can the trustee sell the house while my kids are still young? The trustee, if your terms do not say the trustee can sell the house, the trustee cannot do it. The trustee has to follow your terms that you put into the house, into the trust. If the trustee does anything else, then they're breaching their fiduciary responsibilities. Is the living trust in the state's database system? Who will look over my trustee for following my living trust? So when you create a living trust, it's not filed anywhere. It's not filed with any state's database system. That's a great question. Your living trust is documents that you just put, just like a will, into somewhere safe, like a safe deposit box. But what is in the state's database system is any assets that you put into the trust. So for example, if you put your house into the trust, the title of your house, the deed to your house, now goes under the living trust name. So when people look up that real estate property, they can see the name of the trust. And that is in the state's records. All right. So, but if it's an unfunded trust and there's no property in there, then the living trust is not filed anywhere and nobody even knows that the trust exists, except your trustee, of course. Who will look over my trustee for following my trust? So the fiduciary duties are given by each state. And so if the trustee is not following the duties, well, guess what? Who is going to complain? the beneficiaries are going to complain, because the beneficiaries, you know, if the trustee, for example, sells the house when it should have gone to the beneficiaries, the beneficiary is going to take the trustee to court right away, and the trustee is going to be eliminated and a new trustee is going to be appointed. So if a trustee does not follow the fiduciary duties, the court's just going to take away their responsibilities and their powers. All right, so the beneficiaries will have to speak up. And that's why for minor children, having a proper, a trustworthy guardian is important too. And you can specify who's going to take care of your children as the guardian in your trust. So your guardian would also be managing the trustee too, because they're going to worry about the assets that go to your beneficiaries, your minor children. What happens if the two witnesses die? Does that void the trust? It does not. So it's okay if the witnesses pass away, as long as when the trust was notarized, the two witnesses were present and alive. That's all that matters. If the witnesses passed away later on, it's not going to void the trust. How is a trust valued? Is it at the time you put the properties into the trust? So the trust value, if it's a revocable trust, it can change anytime. When you add more properties in and when you take more properties out, you know, when the market goes up and goes down, the value of the trust keeps changing. So you're valuing the trust at any given time, depending on what assets are in there at that time, right? So it's different. But your question is, you're concerned about estate taxes. Well, to meet the estate tax exemption, that tax exemption keeps changing. So it's when you put the properties into the trust, whatever tax exemption that year has. So like, for example, it's $11.58 million this year in 2020. If you put all the properties into the trust and you max it out at $11.58 million, that's when you look at the tax exemption. So if it goes down in the future, it drops back to 5 million, for example, you're already exempt for this year's exemption. You're grandfathered in. All right, next question. As to irrevocable trust, so if you're creating an irrevocable trust to protect your assets from a lawsuit, how does fraudulent transfer work? Is it still subject to 90 days? So they look at the filing date of the lawsuit. If it's too close to the date of the filing of the lawsuit, or it happens after the filing of the lawsuit, then the court will deem it quote unquote fraudulent transfer. And they'll say, look, the lawsuit was already filed, and then you created the trust and then moved all your assets out of your name into the trust. That's a fraudulent transfer, and they're going to undo everything, take out the assets, cancel the trust, and put the trust back into your name. So that's what a fraudulent transfer is. So that's why you don't want to create a trust when a lawsuit has already been filed against you. You want to do it early on to protect your assets. What types of documentation should we prepare before meeting to set up a new trust? That's the estate planning questionnaire that I have. So I can email it to whoever sends me an email, and you can look at the form and see what documentation and information you should gather to prepare for a trust. Do we have to pay to have a power of attorney now? Can that be funded by a will later? So a power of attorney is not funded, like a trust can be funded. A power of attorney is just a document that you sign and notarize that says, this is who I want to designate as my power of attorney to make legal decisions for me, to decide whether or not to pull the plug for me, to sign any legal documents for me in case I'm disabled or incapacitated. It has nothing to do with funding. It doesn't really involve funding of assets. Okay, so power of attorney is just someone who makes decisions for you. A living trust designates a trustee, spouse, a co-trustee, and a successor trustee. Is this correct? Can a successor trustee be a bank? Yeah, a living trust, it can designate a trustee and a co-trustee. So if there's co-trustees, that means they have to work together to make and manage all the terms of the trust. Oh, that question just disappeared. I don't know where it went to. And then also, like I mentioned earlier, there's a primary trustee and a secondary trustee. So if a primary trustee isn't able to fulfill the responsibilities, a secondary trustee can fulfill it. That question disappeared, so I can't read the second part of it now. If you want to retype it, I'd be happy to answer it. Going to the next question. Do we have to pay to have a power of attorney? Oh, we already answered that one. Okay, next one. When you don't have a will, do the trust beneficiaries get the assets upon the settler's death? Well, like we discussed earlier, when you don't have a will, it's called intestate succession. So it goes to your spouse and then your children. It has that specific order, and that's just California. Every state has a different order. And then ultimately, if you're not named in one of those categories, the properties all go to the state. So yes, a will is necessary if you don't want to have intestate succession. Next question. With an unfunded trust, you do need a will, correct? Yes. With an unfunded trust, if your purpose is to have the assets go into a trust from the pour over will, then yes, you do need a will. But if your primary goal to have an unfunded trust is, maybe you're planning on buying a house in the next year and you plan on putting that house into the trust after you buy it, then you don't need a will because you can just put the house into the unfunded trust when you close escrow. What is the cost of setting up a trust? So the starting price is $1,500 and it goes up depending on the complexity of assets. So if you have the simple one house, one vehicle, your banking, checking account, savings account, then it's a fixed fee of $1,500 plus the notary fees. Notaries usually charge $10 to $15 per signature. If it's more complicated, like you have a lot of different ways and beneficiaries, and you have stocks and bonds, and you have different real estate, and you also have businesses. You can also put businesses into a trust. So if you have like S Corps, C Corps, or LLCs that you want to put into a trust, and it gets complicated, then it'll be more expensive. Does a trust help to shield assets from Medi-Cal or other state benefits for poverty? So it does. So a lot of times, like elderly people who want to qualify for Medi-Cal, they don't want the government to know that they have a lot of assets in their name. So they can put it into an irrevocable trust and then still qualify for Medi-Cal. And that way they don't have to transfer their assets to another person's name. I know some elderly people, they'll put it into their kid's name so that they can qualify for Medi-Cal. And then all of a sudden the relationship will break down and then they don't have any more assets because the kids won't give the properties back. So it's safer to have it in a trust than to just transfer the title to another person. Okay, next question. Do you have to pay the trustee to manage the trust? And typically, how much does it cost? So if your trustee is someone who's close to you, like your spouse or a relative, typically you don't have to pay the trustee. But some people, they designate professional trustees. So you can have, like Charles Schwab or Morgan Stanley, one of those professional places, be your trustee. And in that case, then you would have to pay them because they're doing it as a business. And those costs range depending on who you end up hiring. And if you want to have a friend do it, depends on how good of a friend they are. If they're good friends, maybe they won't charge you. But if they want to charge you, then you guys can negotiate the cost as well. So there's no minimum requirement. It's definitely negotiable. Is there an advantage for putting a property into an LLC before putting it into a trust? What are the pros and cons? So having a business and having a trust is two completely different things, all right? People create LLCs, limited liability companies, so that if the company gets sued, you're personally protected. So for example, if you own a restaurant and your restaurant is in an LLC, if one of your customers slips and falls and hurts themselves, they're going to sue the LLC. And if they win, they can get all the assets of what the LLC owns. They won't be able to touch anything under your personal name. So if you own a house in your personal name, that customer that slipped and fell, they wouldn't be able to touch the assets under your personal name. So that's completely different from having it into a trust. The trust has all these different advantages, there's two different things. So there's not really an advantage for putting a property into an LLC before you put it into a trust. I think it really depends on what your goal is. So if you have a specific goal, then I can help you figure out the best way to plan out your assets. Here's another question. I heard a will must go through probate. Can you clarify again? Here is from the Google Legal Zoom. Suddenly having a last will does not avoid probate. In fact, a will must go through probate. To probate a will, the document is filed with the court and a personal representative is appointed to gather the decedent's assets and take care of any outstanding debts or taxes. So what probate is it's a court that takes care of assets when someone dies. So when you have a will, what happens is you go through probate. But when we talk about probate, we're talking about the really long and extensive system. If you have a will, you go through probate, but the judge will say, oh, there's a will, so let's just follow the terms of the will. If your will says your house goes to your brother, then the judge is going to say, okay, your brother gets the house, and that's done. Really simple. When you don't have a will, then when you go to probate court, the judge is going to be like, okay, where's the will? There's no will. Then let's see, let's try to contact all of these people. Say you're the parent. You're like, judge, there's no spouse, there's no kids. The house should just go to me. The judge is like, well, I can't take your word for it. I got to do my due diligence and find out all the people out there who could have an interest before giving the property to you. So then that process becomes really long and expensive. So that's the difference between a simple will and going through probate and then executing the will versus the long and drawn out probate process. So I hope that explains your question.
Hi, Elizabeth. Can I cut in real quick?
Yeah, absolutely.
First of all, I really appreciate everybody asking all the questions. Obviously,
it's like endless questions.
Yeah, there's some questions we cannot get to because of timing. But I really appreciate you, Elizabeth. You took almost half an hour to answer all these questions, and still we have a bunch of questions that we haven't even touched. So what do you think, Elizabeth? Should we do another session like this again so that the people who haven't had a chance to ask questions, they can come back and talk to you? Or, what do you suggest that they do if they have more questions and they need answers immediately? Should they call your office or should they email you? What is the step to do next for them?
I'm happy to do another session, and maybe the next time we can make it interactive so people can just ask questions and I can, see their face and interact with them. But my contact information, again, is on the screen. So if you guys want to message me the questions directly, I really have nothing better else to do right now than respond to emails. So I'm happy to respond to all your questions immediately and get you answers.
That is just awesome. Do you want to say something?
Yeah, just want to kind of discuss a little bit, Elizabeth. So our team, we've been very blessed to have you on our team and share with us so many tips and values. However, we just want to kind of asking you a little bit, see if, let's say if our team members, if they want to do a living trust and will with you, would you give us some little discount?
Oh yeah, absolutely. So if you contact our office and you tell us that you heard about the will and trust process through the seminar, then we'll automatically give you a 10% discount off of all our fees.
Okay.
Excellent. All right. Thank you for that.
No problem. Just for you, Con.
All right, thank you. So if you want to get a discount, be a teammate with us, and then you get the discount with Elizabeth too. Okay. Awesome.
All right. Let me conclude the session by saying, thank you very much to Khan for hosting this session, and also thank you to Elizabeth for taking the time, an hour of your time to come and talk to our audience, and also to your audience, and giving so much value, so much questions that you answer. At the peak time, we had over 95 people on Zoom and also 68 people on Facebook. And I know hundreds and thousands of people will be watching this over and over again because the information is so relevant. And maybe we can set up another Zoom time, like you say. Next time we'll make it more interactive. But the reason why, there's a couple reasons why we don't make that happen, and we'll talk later about that. But we can try to get some people on and be more interactive that way. But thank you so much. Our time is up. For the Facebook audience, I want to say thank you for joining us. You've been awesome audience. You always participate in all of our live sessions, and I promise you there'll be more sessions that'll be more valuable to your life, especially in this moment in time, in this crisis. We want to bring a lot of value, a lot of information that you can learn from and you can take advantage of. I would love for you to help us out by joining our group page. It's Wall Street to Main Street. Wall Street to Main Street. That's our group page. And on that page, we have so much financial public information that you can take advantage, you can learn from, and you can strengthen your personal finance. And that's our mission, to help you to understand more about personal finance and help you build a secure financial future. And with that, good night, everybody. I see you at the next session, and hopefully we'll get Elizabeth back very soon. Thank you, Elizabeth, and thank you, Khan. Have a good night. Stay safe.
Thank you, everyone. Thank you, Con and Dewey, for hosting. Thanks for all the questions. Good night.
Thank you so much for your knowledge.